So today let us look at shall we start? I will make no problem. All of you are VIPs, so VIP culture should be maintained, right? Once you are free from all your cultural activities, we will start. Yes? So, are you giving me permission now? Yes, very good, right? I am really humbled, right, that you sovereign people of our country, right? And yes, those backwards. Let us now we are doing this one 11th. What I did not get your question. Waldo talk about bringing. Where did Waldo talk about it? He did not. Waldo spoke about different institutions becoming part of governance as part of the future challenges faced by the discipline of public administration, wherein he said that with the multiple actors becoming part of governance, it can either result in anarchy or dictatorship. Two solutions he has provided. Right? You cannot imagine, dream about the things and then start fighting about it. Already in real life we have so many problems. Right? So, Waldo is a good guy. Don't unnecessarily try to. So let us look at, as I said, some of the technical aspects of this PMLA. You can note down all of them. Supreme Court recently has struck down. Section 3, Part 2. Section 3, Part 2 of Benami Transactions Prohibition Act 1988. Section 3 in brackets 2 of Benami Transactions Prohibition Act 1988. And Supreme Court also has said that 2016 Amended Act will only apply prospectively. 2016 Amended Act will only apply prospectively, PROSPECTIVELY, and not retrospectively. And this is when Supreme Court also has said that it will also review PMLA. This is when Supreme Court has said that it will also review PMLA, Prevention of Money Laundering Act. Why? Because the 2016 amendment to PMLA also spoke about retrospective legislation. 2016 PMLA amendment also spoke about retrospective legislation. That means the act would be applying in a retrospective manner also, right? Now let us look at what are the major contentious issues in PMLA, major problematic ones. First and foremost, Section 3. What is the Section 3? It defines money laundering. Now, what is the problem with this definition of money laundering? This definition is so vast, its scope is so wide that anything can be called money laundering. Are you getting the point here? It is not properly defined. What is exactly money laundering? Not properly defined. They did not attend our yesterday's class to know what exactly is money laundering. So they said that everything is money laundering. They did not properly define what is money laundering. Section 5. Section 5. Attachment of a property. Attachment of a property. Again, it gives a huge amount of powers. It gives huge amount of powers to ED. ED means Enforcement Directorate, to attach properties. The safeguards are there. Safeguards are there. But safeguards are there, but they are not sufficient. But they are not sufficient. Next, section 8(4). Section 8, subsection 4. Section 8(4). Taking possession of attached property. Taking possession of attached property. Taking possession of attached property. As we study, today also as part of our judiciary, as has been pointed out by various critics of our legal system, the process itself is a punishment. You don't require any more punishment. The process itself is a punishment. Why? Because once your property is attached by ED, once again for it to come back to you, it will take minimum light years. Minimum light years. Maximum time has no limit. Right? That is where the problem is. Once it is attached, it becomes almost impossible for you to get hold of the property again. Section 8(4). Next, section 17. Search and seizure. Search and seizure. Search and SE. Search and seizure of properties. SEIZURE. Seizure. Then section 18. Search of persons. Section 18. Search of persons. For example, what is the problem with sections 17 and 18? They can come to your house at any point of time. They can search, they can seize properties without giving you reasons also. The proof of a burden will be on your shoulders. And they can also arrest you. You can see in the case of Shah Rukh Khan's son also, what happened there. He was arrested on flimsy charges and he was kept in jail for a very long period of time. Next, section 19, powers of arrest. Powers of arrest. Powers of arrest. Normally, this arrest should be done only when there is evidence of a crime. Here, on the basis of the suspicion also, you can be arrested. After you are arrested, they will ask you to prove your innocence. Right? Then section 24, very important. Section 24. Reverse burden of proof. Reverse burden of proof. Section 24. Reverse burden of proof. What does it mean? The government will say that you are the accused. Now, prove your innocence. Otherwise, you will be treated as only accused. Normally, as we study in rule of law, you are innocent till you are proved guilty. But in this Pmla, it is reverse burden of proof. Administrative law. That's what we said. Section 44. Section 44. Offences triable by offences to be tried. Offences to be tried. TRIED in special courts. Again, it goes against the first principle of rule of law. You can be called guilty only when you are proved so by ordinary courts in an ordinary legal manner. in this case, the special tribunals will be there. Those tribunals will have their own procedures. They have their own rules and regulations. They have their own different forms of witnesses and proof. Right? This is another problem. Next, section 50. Section 50, statements made to ED officials. Statements made to ED officials. Normally, as we know, if you are making any statement in front of a police officer, it cannot be admitted in a court of law. The statement can have only legal validity only if it is there, if it is made in front of a magistrate. Right? But in case of ED officials, even the statement made to ED officials also can be used as a witness in a court of law. Supreme Court has said that section 8(4) could be misused. Section 8(4) could be misused. Why? Because the ED can take the possession. ED can take the possession of a property. ED can take the possession of a property even before a formal order of confiscation is passed. Even before a formal ED can take the possession of a property, even before a formal order of confiscation is passed. Confiscation. Normally, you can confiscate the property only by following due process of law. You need a proper order for confiscating the property from the judiciary. In case of this section 8(4), ED can confiscate your property even without any due process of law also. Supreme Court has said that it can be misused. Next one is, next problem is with this enforcement case information report. Next problem is with enforcement case information report. ECIR, enforcement case information report, which is similar to first information report. ECIR, enforcement case information report, which is similar to first information report, FIR. Right? Right. And the Supreme Court has said that ECIR cannot be equated by FIR. ECIR cannot be equated by FIR. Right? That is what the Supreme Court judgment in July has said. And ECIR is only internal document, so it need not be given to the accused. ECIR is only internal document. The problem with the July judgment of Supreme Court. It has said that ECIR is only internal document, it cannot be given to the, it need not be given to the accused, unlike FIR. ECIR need not be given to the accused, unlike FIR. So what is the problem here? What is the problem with this ECIR? You are the accused. You don't know what are the charges against you, and you are asked to prove your innocence. Pardon? Very good question. Wait for enforcement director to come to your house. Right? Right? Wait for. Yeah, nobody, it will be, Supreme Court, this is how our judiciary judgments. All the judges should be put in museums and zoological parks, for their brains. They said that, Supreme Court judgment has said that this ECIR is only an internal document of enforcement directorate, so it need not be given to the accused. It is not FIR. But enforcement directorate can arrest you on the basis of ECIR, and they can take action against you on the basis of ECIR without telling you what your charges are. And Supreme Court has upheld this provision of Pmla. This is where it can be totally misused. Nobody will tell you what your crime is, and they will arrest you, and then they will ask you to prove your innocence. without telling you? Very good question. I like all you people. All of you are ready for section. Same thing. Section. What is this section? Is here section 17 and 18. Section 17, 18, 19. Right? Wait for section 17, 18, and 19. If you have any property, there you don't have to worry because you don't have any property. But cases can be filed against you. Right? Yes. Yeah. That is what I am saying. You don't know what I mean by attachment of property because you don't have any properties. Otherwise, if you have any property, ED attaches your property. That means it will put a seal. You cannot use that property and you cannot sell it. You cannot stay inside it. Right? That is what. First have properties, then you will get answers to all these questions. Right? Right now we are only liabilities, not assets. Right? Yes. How to become ED officer? Very good question. Some of our students are working in ED also. If you are getting into IRS IT, you can get into ED. IRS income tax. Some of our students are there in ED also, or IRS customs also. Because you have seen this girl, she came some time back. She worked with ED also. Right? IRS IT and IRS customs. There you will get into ED. Right? Then you can attach as many properties as you want. Right? So this is what another issue here. Why? Because what is the problem here? As we have said, the problem here is that ED will arrest you on the basis of this ECIR. They will not tell you what your crime is, and they will ask you to prove your innocence. And Supreme Court, in its judgment in July, the 3-member Supreme Court bench has upheld all these amendments also. Right? Where to put all the judges. As we studied today, what we are witnessing is what is called executive judiciary. That means judiciary has become nothing but an extension of executive, like what we discussed regarding legislature. Executive judiciary. You are giving complete stamp, you are putting your rubber stamp on the unconstitutional decisions taken by the executive which restrict the fundamental rights of the people also. You are questioning the basic law of the land with these kind of legislations. And what is the argument given by the Supreme Court? Supreme Court has said that we are living in extraordinary times wherein national security is always paramount. So in the name of national security, we have to compromise with the individual fundamental rights of the citizens. So let the police arrest you, let them kill you. In the name of national security, you have to suffer in silence. That is what it is. Yes. Yeah. Yeah. See, the problem as we discussed, election commission is a constitutional body. Does it have any independence? You ask any election commissioner, he will file PIL against you, saying that how dare you say that I am independent. Prime Minister is watching. It is not about constitutional body or statutory body or the bodies which have been set up by an executive resolution. It is about the people who are manning those institutions. That is what we say all the time. At the end of the day, what really matters is the people. And recently you must have seen what did the government of India do before making giving these extraordinary powers to ED. What did the government of India do? They have increased the tenure of the directors of CBI and ED to 5 years. Right? Pardon? Yeah, this is like UAPA. We will also discuss UAPA later as part of our Indian administration also. Right? This is what next problem as we have discussed is, as yesterday we have mentioned, the changes that were made to Pmla, they were passed as a money bill. They were passed as a money bill. They were passed as a money bill. So the Supreme Court can easily strike down all those amendments for procedural ultra virus. They were passed as money bills for procedural ultra virus. And what are the other problems? Pardon? The Supreme Court can strike down the amendments to PMLA for procedural ultra virus. Procedural ultra virus. Why? Because proper procedure was not followed in passing the legislation. Now, right now, the matter is in the Supreme Court. It is there with the 5-judge Supreme Court bench, whether they are money bills or not. And when will they decide? After 5-10,000 light years. Right? Right? Supreme Court, that is what yesterday, if you remember in our class also, what we have studied, that the second most important function of our Supreme Court is to, judiciary is to ensure constitutional governance. Both the legislature and executive work within their limits and they work strictly according to the provisions of the Constitution. The Constitution says that there is a different procedure for ordinary bills and there is different procedures for money bills. In case of money bills, you don't require the support of Rajya Sabha. Whereas in case of ordinary bills, it should be passed by both by Lok Sabha and Rajya Sabha. And the problem here is that, as we have discussed yesterday also, someone is calling. Yes, any problem? Just listen to me. If any kind of doubts, I am here to solve all your doubts. If you don't have any doubts, I will create doubts in your mind also. Right? So the only person who is allowed to talk in the class is me only, the person in front of you. There are no fundamental rights. Yesterday you must be getting carried away by the fundamental rights discussion. No. Right? The administrative law only, which is martial law in our class. So coming back here, in case of a money bill, only Lok Sabha has the power. In case of ordinary bills, both Lok Sabha and Rajya Sabha has equal powers. Now, when these amendments to PMLA were done, at that point of time, Modi government did not have any majority in Rajya Sabha. That is the reason why it was introduced as money bill. As we have discussed, all the critical legislations were introduced as a money bill during the between 2004 and 2014 and 2019 to avoid Rajya Sabha scrutiny. And now there are so many of those bills were right now pending in the Supreme Court, including this right to privacy also, making Aadhaar compulsory. That was also introduced as money bill. And Supreme Court is yet to come out with a judgment in all those cases, whether to declare those legislations as ultra virus or not. Right now, that is what exactly the situation. When will the Supreme Court come out with the judgments? Don't ask me those kind of doubts. Alright? Then what are the other issues related to PMLA? Absence of a procedure. Next issue related to PMLA is absence of a procedure to commence investigation and summoning. Absence of a procedure to commence investigation and summoning of people. To commence investigations and summoning of people. The problem here is that you don't know whether you are summoned as a witness or as an accused. You might be summoned as a witness, then they will say that we have summoned you as an accused and they will arrest you. Because there is no proper procedure also here. Next problem is and section 50 of PMLA, it enables authorities to summon anyone for interrogation or to produce evidence. Anyone for interrogation or to produce evidence. Anyone will be summoned. Anyone can be summoned. It can be misused. For interrogation or to produce evidence. Then in the absence of any written documents, it becomes impossible for the accused to prove his innocence. in absence of written documents, it becomes impossible for accused to prove his innocence. Why? Because there is no what is called FIR here. There is only ECIR. You don't know what kind of evidence ED has against you so that you can prove your innocence. This is another problem. And of course, retrospective application of law. Next problem is retrospective application of law. Retrospective application of law. That means the properties which you have purchased before 2016 also can be investigated by ED before the amendments were made to this PMLA, right? So this is what we say ultimately about the basic issues related to PMLA. Let us see what the Supreme Court will do. We are waiting for the Supreme Court. So right now there is no full stop. There is only semicolon and a comma. Let us see what the Supreme Court will do. Now that the matter has reached the Supreme Court, there will not be any full stop also, right? So that is what we can say. Yeah, you can quote all these things. As we have said, administrative law is an evil, it is a devil. Yeah, devil looks like God in front of a PMLA. Yes, very bad. I gave you the example. For example, at the point of time when the transaction had taken place, it was not illegal. That is the reason why you have conducted the transaction, right? After 5 years, the government says that it was illegal. How do we know what is legal and illegal unless the law is there? No, that is what we say. Retrospective application of any law is always against the principles of natural justice, whatever may be the cases. It is never good. Vodafone case, it can be done, but no country, no person with head above the shoulder will do any of these things. It will be struck down by judiciary. That is the reason why in the Vodafone case, the government of India had to eat the humble pie and withdraw retrospective legislation. Why? Because Vodafone has threatened to confiscate the properties of Indian government in foreign countries. It would be hugely embarrassment for the government also, right? And who had brought up this retrospective legislation in income tax? Our finance minister at that point of time, Pranab Mukherjee. Pranab Mukherjee was the finance minister. So that is the reason why at the end of the day, recently the government of India had withdrawn that retrospective legislation. You cannot justify this retrospective legislation in the International Court of Justice. How can you justify it? Right? I have done a transaction which is legal today. After 2 years, you say that it is illegal and you pay the penalty. Right? That is where the problem is. Whatever it may be, it can never be justified. It can never be justified. Right? So let us proceed and come back to our Indian administration. Yesterday we were talking about judiciary, as all of you know. I don't know whether you know or not, but I am making the assumption that you know. We were talking about judicial activism. We were talking about the different phases of judicial activism. Yesterday we were talking about the first phase of judicial activism, which we called it as passive judiciary. Yes,